Hey, what's going on? Have you heard about our radio show? That's right, there's a medical marijuana radio show, and I do it for you every Thursday night at 8:30. In fact, the podcast is available ahead of time every week, and you can get it at 420lawoffice.com. Just click 420 Radio Show, and you can download the podcast, and you can subscribe by clicking a button, and it's going to show up in your phone or in your iPod. So be sure to check out 420 Law Office Radio. I think you'll find it's rockin'. All right. Hello, Stuart Richland here from 420 Law Office and here on the YouTube channel. Today I'd like to speak a little bit about the new draft Attorney General's guidelines that have been drafted by our new Attorney General, Kamala Harris. And I supported Ms. Harris, and I'm very pleased that she's in the position she's in for our state. I have a lot of respect for her. But I do have a bit of constructive input, and that is, don't bother, please do not rewrite or write a new Attorney General's guidelines. And the reason is because there's no need for a new guidelines. Remember, SB 420 stated that the bill would require the Attorney General to develop and adopt guidelines to ensure the security and non-diversion of marijuana grown for medical use. And that's been done. Attorney General Jerry Brown, now our governor, in August of 2008 promulgated the Attorney General's guidelines in furtherance of this bit of legislation, and that's all there is to it. There is no further legislative mandate or authority for an annual or a restated guidelines to be done by each and every Attorney General as they go through the office. In fact, doing so will have a very negative effect, and that is it will upset the apple cart, because many of the cities and counties already have legislation and ordinances that specifically adopt the provisions of the 2008 guidelines. Moreover, the patients and their collectives have been doing their best to adapt to the collective guidelines, the Attorney General's guidelines that were already promulgated. So the idea that they are going to be now recast randomly by the executive branch representative, the Attorney General, is not a good idea. Besides, there's been no particular need with reference to security and non-diversion, nor is the revision tailored to security and non-diversion, but it's a complete reworking of the guidelines and is really very unfavorable for patients at this stage to have to reinvent their entire approach to medical marijuana with each successive Attorney General, etc., especially after they've committed to leases and engaged in contracts in reliance on the state of affairs. Of course, there is a provision in our Constitution against the impairment of contracts. Then again, the Attorney General's guidelines really are not the law. They are merely guidelines, but they're intended to be relied upon by law enforcement as well as by patients. And so, and cities and counties rely upon them. So I think it's a bad idea to rewrite them at this stage. Those of you that really want to know what's going on with the guidelines and would like a consultation, I would love to have you through my office for my consultation. This is a copy of the latest version of my book. It's about 130 or so pages, and it contains a lot of reprints of material you need, as well as custom information that I've put together to help you understand how medical marijuana law works here in the state of California, as well as, of course, federal, state, and local law in proper perspective. And it begins with that comic book because I think it's really helpful to learn things visually. You'd be amazed at how much information I can get across visually in an hour. Our consultations are an hour, and they're here in my office. They're one-on-one. Here's an interesting new graphic I put together. It is a graphic entitled, "Is there such a thing as legitimate delivery in the state of California?" If that's an interesting question to you, then you'll certainly want to see how I analyze that for you in my new book. In addition to the newest version of my book, which has a really cool comic I'll be showing you about how delivery may work, there's also an interesting page there about how the non-deductibility case works and what the solutions are for the non-deductibility problem under the case of Champ versus IRS. And then once you're certain that you want to have a collective, you might want to come through for this little upsell. This is the kit that allows you to create your own nonprofit, lickety-split. This book is called But How to Corp, and it explains how mutual benefit nonprofit corporations work in the state of California and how they are perfected. as well as accompanying perfectly by number this book, which is a corporate book that contains bylaws and other information, as well as being a beautifully American-made, hand-tooled leather, really pretty book with a raised spine and a little cutout here for you to put the name of your collective into. The purpose of all of this is to enable you to begin to demonstrate that your activity here in the state of California complies with California state law, that you're a nonprofit, that you have membership agreements, that you have qualified members that have been verified, etc., etc. Well, I look forward to sharing all that information with you here in my Hollywood office, so give us a call for an appointment, and we'll be very glad to book it for you. Until then, take good care.